Welcome to Bloomberg Law on Demand. I'm Pacchia. On July 1st, the United Kingdom will be enforcing its new anti-bribery law. That leaves less than 3 months for businesses to revise their anti-bribery compliance programs. Joining me now to discuss the landmark legislation, we have Jonathan Halpern. He's a partner at the law firm Bracewell Giuliani, based here in New York City. Jonathan, thanks so much for coming in. Welcome to the program.
Thank you, Lee. It's a pleasure to be here.
So Deloitte came out with a poll earlier today suggesting that out of 1,000 business professionals, over 70% knew that there was going to be anti-corruption enforcement in the coming year. But when asked the question if they knew what was in the UK Anti-Bribery Act, over 70% didn't understand. I was wondering if you could briefly take us through what's in the UK anti-bribery law. What does this ultimately mean?
Yeah, Lee, and that's also following the guidance that a number of critics have said have provided precious little guiding to companies that want to do the right thing and take this opportunity in the next 2.5 months to implement measures to help protect their companies from this law. So what is the UK Bribery Act? In essence, it's somewhat akin to the counterpart of the U.S. law, the Foreign Corrupt Practices Act. It's an anti-bribery law. Unlike the FCPA, the UK Bribery Act makes it a crime for companies who fail to prevent bribery in the workplace. And such companies would be liable for infinite fines if they're held criminal. However, there is a defense, and that defense is what the guidance was aimed at, and that is if the companies implement adequate procedures to help prevent bribery from occurring.
I want to get to the guidance in a second, but before we do, how big a problem is corruption and bribery throughout the world? I don't remember hearing a whole lot about it in previous years, and now all of a sudden, this law is a really big deal. Everyone's talking about it, and no one really seems to understand how this is going to play out.
Yeah, it's a good point. It's really in the last few years on the global radar screen.
And the UK was catching a lot of flack for being so-called somewhat soft on anti-corruption and bribery issues, and now all of a sudden they came out with this law. And
yeah, I mean, it's a good point. I mean, it's long in the making. They had a anti-bribery law in the books going back to 1889. About 13 years ago, they committed to implementing and enforcing an anti-bribery law as a member of the OECD and a signatory to that convention. And finally, they're kind of catching up. The UK has caught some flack from those who said they pulled back on some of the investigations, BAE and so forth. But now they're trying to put some teeth into this law by, again, making it a crime for a company that doesn't have effective or adequate procedures. It makes it a crime for individuals not just to offer and give and promise and authorize, but to receive, to take bribes as well. And there's kind of vast jurisdictional issues. Unlike the FCPA, also facilitation payments, what are known as grease payments, these very limited, small amount of payments to low-level ministers to perform routine, non-discretionary duties like getting the immigration officer away from the football match to come over and do his job, to review immigration documents, stamp them, or for someone at the electric company to turn on the lights, that sort of thing. It constitutes a bribe under the UK Bribery Act. There are exceptions under the corresponding FCPA in the United States. And there's some other differences as well, but the broad jurisdiction is for companies. I mean, who would this really apply to? So if you're a U.S. business or some other multinational and you're, quote, carrying on business or carrying on some of your business in the U.K. through operations in Britain, for example, you face potential liability. If you have someone what's called an associated person, and it's really anyone who is doing any act on behalf of the corporation, who makes a bribe payment, that is, with the intent to obtain business or keep business or obtain a commercial advantage for that business organization, the organization could risk exposure.
Right. Now, the law went through a round of newly issued guidance. I think it was about a week ago or so. This new guidance came out on the rules and regulations of the law and how they'd be applied. It seemed to cause a little bit more confusion than the initial act did, especially insofar as areas relating to jurisdictional reach. How has that played out in your opinion? Is that criticism valid?
Yeah, I mean, I think some of it is. I mean, the critics are saying the guidance undermines the act. It's too soft on especially areas like hospitality expenses, which generally, as long as they're bona fide and reasonable and proportionate, get a pass. And they say that there are other exceptions, that if there is a bribe payment down the chain of supply, contracts after contracts away, that may be insular. On the other hand, this is not an ABC how-to guide to avoid liability, but there are some broad principles that are stated. And those principles generally, and dare I say, the proof will be in the British pudding on this,
right.
But they're principles of proportionality, reasonableness, common sense,
right.
And who's to decide that? If you were a company, if you're a general counsel, those are going to be very tough calls to make.
Right. It's great that you're pointing out those principles. It seems the law has a broad amount of discretion built in on the part of the prosecutors and the courts. In your opinion, is that a wise way to put legislation out, especially on something relating to anti-corruption and bribery?
It's not wise, but I think these are unwieldy subjects, and we've actually seen how unwise it can be. For example, in the Foreign Corrupt Practices Act, which has been on the books since.
Does that have the same amount of discretion built into it that the UK law has?
Well, often the Justice Department and the SEC will take a definition and make it very elastic.
Okay.
And because there's been rather a paucity of case law, for example, who is a foreign official? How far down does it have to be? I mean, there is a definition, but there's a stretch to that definition. So according to the U.S. government's view, for example, it would cover a low-level employee of a state-owned or controlled entity. So there is that risk of, if you have a criminal law, it should be clear and should set out really definitive guidelines and specifics as to what's criminal and what's not, what's safe, and how you can comport your own business and your company's business and protect yourself.
When you talk to people in your field of practice, what do they think is going to happen here? Are we going to see a wave of prosecutions and court cases emanating out of this act, or is this something where people expect the UK government to tread lightly?
Yeah, and it's a very good question, and I should say here, I'm not licensed in the UK. We have a London office, and we're very busy.
But I'm sure a lot of your clients have footprints in the country.
Exactly right. I mean, this is a great both position of concern and also an opportunity to protect themselves, to put in place these compliance procedures so that if an employee directly of the company or of a foreign subsidiary goes off the reservation and as a rogue makes a wayward improper payment, that the company is protected. So directly to answer your question, I think at the outset, the Serious Frauds Office of UK and the courts will be very careful, and they'll be considerate of what are the real egregious cases. I mean, I suspect for, let's say, a U.S. company that has an office but not much more in the UK, and that there is a questionable payment in China or Uzbekistan, for example, they would take it very seriously, but also consider how to proceed, whether that's the case they want to bring.
Let's jump to the regulatory regime in the United States for a second. What does this act mean for the FCPA? Are we going to see amendments or revisions to the way we approach these issues?
Yeah, already there's a lot of pressure on the United States to make facilitation payments illegal. They're exempted, but they're very narrowly limited, and they will be scrutinized in the U.S. I think this will add perhaps to that pressure, but there's also a recognition that change just can't come overnight in special areas of the regions of the world where the hot regions, and this is just customary to make these small ministerial payments for low-level officials to do their job, to expedite or facilitate jobs. I think there's going to be pressure to no longer have that exemption. I think there's just increasing global enforcement. There's cooperation between UK prosecutors and law enforcement officers with their counterparts in the U.S. and in other parts of the world. I think these are just part of the global mosaic of a compliance program that companies with business abroad have to take very seriously.
this law is garnering an awful lot of attention. When you look at this new act from a 35,000-foot perspective, are there any industries or activities that are particularly susceptible under the new regulations?
Yeah, I mean,
who's staying up at night worrying about the law? It's a good question.
Well, really, anyone who does business in the UK, and especially in other areas, it's exceedingly broad. But look, to be reasonable about it, and that's what they say they're going to be following what's reasonable, is you want to have a real comprehensive risk assessment of your business.
So how do you do that?
I mean, it's great. I think that there are three points on that. First, I think what you do is part of the risk assessment. Are you doing business in the UK? What is it? What are your operations there? Who's conducting business? How is business being conducted? Second part of that, where else are you doing business? Are you in the hot regions? I mean, are you in New Zealand and Denmark, or are you in Far East Asia, in the China's, or former Soviet Union republics, in the Middle East, Africa, or Brazil?
That's
just
a
by
lot
way
of places.
of examples. That's just by examples.
Right.
I mean, there's a Transparency Corruption Perception Index that lists or that ranks the perception of corruption for 178 countries. UK beats out the United States by 2 on that, from 20, and the US is 22. But there are other things. So once you do that assessment, you also find out, how is business being conducted? How are we getting our goods and services to the market? Is it through agents, third-party representatives, distributors? Are we operating through a branch or a subsidiary, a JV that we have control over? Part of the watchword here is what level of control are we exercising over those chains of distribution? Once you do that and you identify the highest risk, then you put into place strong procedures and policies that include A, due diligence, and B, training. And the third thing is you have high-level oversight supervision all the way down to the region managers, the country managers, the office managers, and then you have a period of monitoring and review.
Wanted to ask real briefly, what does this mean for advisory firms and law firms in particular? Is this going to be the Sarbanes-Oxley of UK law?
Well, you know, it depends. It's a good point. I mean, I think
there's an awful lot of work here.
There's an awful lot of work. It doesn't have to be soup to nuts. I mean, what the UK guidance is saying is that it has to be reasonable, common sense, proportionate. This is an opportunity for companies to really put into place safeguards to protect themselves and to really eliminate or reduce the risk. And so law firms, can go in very quickly, help assess that risk, and map out a compliance program so that, based on what we know and based on, in the United States, the U.S. sentencing guidelines template, that we can help protect companies, protect themselves going forward. It's a great opportunity for companies, and it depends. A larger company is going to have to do more sophisticated, depending upon where it operates. A smaller company to do less, but it still has to be reasonable and reasoned.
Very good. I think this is going to take a long time to play out, but we're going to have to leave it there. Jonathan, I want to thank you so much for coming in today.
My pleasure, Lee. Thank you.
This is Jonathan Halpern. He is a partner at the law firm Bracewell Giuliani, based here in New York City. If you'd like to learn more about the issues we just discussed, go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.